Good afternoon and welcome to the AMVA webinar series. My name is Kevin Lewis. I'm the Director of Driver Programs at AMVA, and I have the privilege of being the host for today's webinar on medical certification issues. What is the jurisdiction to do? We have a great speaker for today's webinar, Mr. Bill Quaid, who is the FMCSA Associate Administrator for Enforcement and Program Delivery. Bill is here to address the many medical certification questions and concerns that have surfaced since the compliance date of January 30, 2012 came about. When Bill finishes his presentation, we're going to open up the webinar for any additional questions the attendees may have. However, since we have over 200 folks on the webinar, it may be a little unwieldy to have everyone try to ask their questions at the same time. I'm going to suggest that anyone who has a question to please submit it during the webinar by using the Questions tab on the webinar home screen. We will then be able to send those questions to FMCSA so that they can be answered once Bill finishes his presentation. We have one request. We know we have several groups listening in today's webinar. If you are a member of a group or heading up a group, please send us an email with the names of everyone listening in so we can have an accurate head count of the number of the participants of this webinar. That's really all I have. So, Bill, whenever you're ready, please take it away.
Okay. Well, thank you, Kevin. And you know, as Kevin said, this is Bill Quaid, and I'm really happy to be here and get to talk a little bit about the medical certification as part of the CDL. I also have Bob Redmond here with me. I think most of you probably know Bob, and you know, to the extent that the questions that you type in are hard, then I'll just turn it over and kind of let Bob take it. But as we start, I want to start by taking us through the timeline. We had a final rule on the medical certification that was published back in December 1 of 2008, and it was effective in January 30th of 2009. And the state compliance date was obviously January 30th of this year. So that's a date that's gone past, and I know that we're working with all of the states in order to gain compliance and make sure that we all get on the same page as quickly as we possibly can. Following the rule, we did some amendments to the rule, which were significant after we published the original rule. We replaced the requirement for the SDLA, and SDLA in this case, you know, that's our terminology for State Driver's License Agency. We replaced the requirement to return a date-stamped receipt to the driver and just require that the medical certificate that's collected be date-stamped and posted in posting their certificate information to the SIDLIS record. Also, that the motor carrier and the driver should use a copy of that med cert for up to 15 days to allow the state time to post that record. Other amendments, one of the amendments was to keep in effect the requirement that the drivers carry their medical card until January 30th, 2014, and that the carriers retain copies of those cards. I think that was our reaction to the knowledge that there were some states that were not going to be able to comply with the rule by January 30th, 2012, and we didn't want to have drivers out there on the road that couldn't, you know, where the states weren't ready, that were running into trouble with the officers. So we had them keep the cards for 2 more years. The important and key point here is that we did not extend the compliance date for the states. We still very much want all the states to get on board, you know, if you're not on board already, as soon as humanly possible. I think that having all the states on board for a period of time before January 30th of 2014, when the drivers actually do stop carrying the medicals, will allow us time as a community to make sure that our system is as robust as it can be, so that, you know, we don't have drivers out there that, you know, after the date happens, that are not carrying, you know, that they get caught, they don't have their medical anymore, but the information's not on the system. So we think that, you know, extending it that date, even though we hope that all the states get on board long before January of 2014, that we have that opportunity to make sure our system is robust while there's still that backup. In this rule, you know, we've got requirements for the drivers, we've got requirements for the carriers, we've got requirements for the states. The drivers first must self-certify. They must certify whether they're in interstate or intrastate commerce, and they must certify as to whether the regulations for the medicals apply to them or don't apply to them. You know, we call that accepted from Part 391. I think that's kind of awkward terminology. It's do the medical requirements apply to you or not? And so those are the certifications that drivers are required to make. They're required to provide the state driver's license agency with their medical prior to issuance or starting January 30th or the next time they renew after that. And so all the current CDL holders should have a medical on file with the state, you know, under this 2-year period by January 30th of 2014. We did put out some information regarding the drivers, you know, specifically for the drivers to explain to them this requirement for the certification, some frequently asked questions. They're on our website. I know they're also on AMVA's website. So one of the outreach efforts that we have made, I think there's still a lot of room for us to do more outreach to the driver community and make sure there's a lot of understanding. I know a lot of the states have also done your own outreach towards that, but I think one of the things that you know, we're hearing through anecdotal feedback is that we still have a bit of a learning curve out there in the driver industry towards making sure everybody's aware of these requirements. As far as the state requirements, again, the biggest one is record the self-certification status, record the medical certificate information, record that medical status as certified if they have their certificate on file, and provide that information to the authorized users, that being the motor carriers and the drivers themselves, as well as the law enforcement community, obviously. You know, we are requiring that the states update their medical within 10 days of a driver providing it to them, placing the variances on file, not issuing a CDL if the driver is not certified and they're supposed to be, downgrading that CDL within 60 days if the medical expires or there's some other reason they become not certified, and notifying the driver of the downgrade. If a driver fails to self-certify by January 30th of 2014, the driver is considered to be an interstate non-accepted, which means they need the medical, and their status should become non-certified, and the states would begin to downgrade that license to a non-CDL. So that's another one of the reasons why we really want to make sure we get the word out to the drivers in a timely fashion, so that everybody is aware that they're supposed to and need to self-certify before January 30th, 2014, or be subject to having their license downgraded. On the motor carrier requirements, the motor carriers are required to verify the medical status on the driver record, place that in the driver qualification file, and annually update that, annually check to make sure that the driver is still certified. This is part of the motor carriers are already required to check the driving record. Putting the medical status on the driving record, we have that all one action by the motor carriers. So it's pretty seamless, actually, from the motor carrier point of view. Now, as we went to implement this provision, obviously there's been a lot of discussion, but significantly, AMVA put together a medical certificate working group with recommendations, and these are the 3 recommendations that came to FMCSA, and in short, we agree with all 3 of the recommendations. The first one, that we're not going to exchange information on accepted drivers in interstate or intrastate. That is, drivers who do not require medical information, even if the state happens to have it, we're not going to exchange that information. The second one, that if the driver is interstate and they require to have the medical information, we're absolutely going to exchange it. That was a kind of a no-brainer, but you know, it's always nice that we can agree on things. And the third one is the intrastate drivers who require medical information. And the recommendation is that the information must be sent in acidless messages if the source jurisdiction has that data on record. We have agreed with this recommendation. We do note that it brings up some concerns. I mean, we're going to have to, as a community, and together with the law enforcement community, really make sure that we understand that provision and what is and is not being exchanged, so that we're getting the information correct on the roadside and making the right decisions based on the information we have. So, from our perspective, the benefits of this rule, first off, I will say this is the first step in a phased implementation to improve our medical fitness program. And I know there's been a lot of discussion about the fact that this was not the appropriate first step, or the appropriate first step was to get the doctors on file. And there may be some valid points. Actually, there are some valid points in that argument. Having said that, our agency made a decision that this was going to be the first step, and so we are in the process of implementing that. This requires, again, big thing, it requires the drivers to medically update their certifications. The reality of it is a driver, once they're, right now, if their medical expires, they can just kind of forget about it and leave it alone until the next time they get roadside inspected, unless they have a company that's really good and on top of them. And the people who are most likely to leave medical problems alone are the people that actually really need to see doctors. That's, there's just human nature. When there's news you don't want to hear, you avoid going. And so, it's important that those drivers are medically qualified on a regular basis. And then providing access at the roadside to this medical certification status. I want to say a couple words about the National Registry of Certified Medical Examiners. We did recently publish the final rule on that rule, which requires the doctors to be trained and tested and be certified as being a medical examiner by FMCSA. On or after May 21st of 2014, motor carriers and drivers are only allowed to use doctors on this registry to get their medical, and that will address the second one of our big problems, is making sure that the doctors who are performing these exams are really aware of what our requirements are and are not. And the fact that some of the issues that are brought up that we're going to attempt to address in this webinar are evidence that right now we do have doctors out there that are not performing these exams necessarily correctly, and we need to raise that awareness. This rule will do that. The doctors are also going to be required to periodically go through recertification, and the results of all the examinations will be recorded, whether they're passed or failed, in the National Registry, which is an important step. And so that's the second step in our process. The third step is our National Registry of Certified Medical Examiners Rule Part 2, and the sequel is all about having those doctors report the information to an information system that will feed your information systems automatically in some fashion, which hasn't quite been worked out yet, but so that the drivers themselves are taken out of this whole equation. And then we're reducing the fraud possibilities, and we're reducing the walk-in traffic or data entry and a lot of other things that I'm aware that this rule, those types of implications that I am aware this rule has on all of your operations. And so we really think that that's the next best step. It's the third step in the process. It's a key step in the process. We're planning on publishing a notice of proposed rulemaking early next year, and with a final rule by early 2014, hopefully having it in place and effective by the time the medical examiner rule goes into effect in 2014 also. So that's the timeline we're on with respect to that follow-on rule that we're working on now. And this slide, again, goes into some of those benefits which I just spoke to. Now, we get to the good part of the webinar. We have, been hearing through a lot of channels and through AMVA, and appreciate the feedback that everyone's been giving us with respect to this rule. And one of the things I want to make sure that we do during this webinar is be as responsive as we can. We've got a number of issues. Again, as was mentioned earlier, if you have issues that come up, and I know that we're already seeing that some are coming over the the email, please type in your questions and we'll get to them. Now, the first big issue is we've got medical examiner certificates that have missing information, it's illegible, the driver hasn't provided a self-certification, there's other problems like the expiration date is longer than what's allowed, there's no information on variances where variances are needed. In these cases, the medical examiner certificate is not valid and we do not want you to accept it. You know, one of the things that's going to happen, I think, during this 2-year implementation period is even before the National Registry gets online, we're going to educate a lot of doctors about what they're allowed to do and what they're not allowed to do. So in any of those situations, our guidance to you is that you should not accept that medical examiner certificate. Now, there is a situation, our old medical examiner certificate, and frankly, the certificate, the version we use to do the requirements for SIDLIS specs, have 5 types of medical examiners. However, our regulation allows for other practitioners, and our new medical examiner certificate allows for other practitioners. So it's theoretically possible that your state may allow other practitioners to do physicals, and if they do, and somebody may present you with a card that has other practitioners. And if they do that, then our guidance to you is pick the one of the 5 types of doctors or current practitioners that is closest to this other type of practitioner. I mean, we allow for certain nurses to do these medical exams now if the state certifies them. If your state certifies some other different kind of nurse, you know, pick the nurse category. Just pick the one that's closest. It's the best guidance we can give right now. And in the future, we'll be, you know, modifying the specs. I really don't know that I think this is a common problem, but where it does exist, that's the guidance that we have. If a driver provides you a medical examiner certificate and the missing information is the driver's information, the things the driver is supposed to put on there, like their signature or their address, please let the driver complete the signature and address. You can verify that with the signature and address that's on the license. I think that's appropriate, but you know, if it's the driver information, let the driver fill out that information and then accept the medical examiner certificate. If there are existing medical conditions, maybe the medical examiner certificate approves the driver, but the driver has a disqualifying medical condition. Or the medical examiner approves the driver, but he can't pass your vision test. In those cases, the certificate is invalid, and you should not accept it. Again, if the doctor has made a mistake, and again, different states have different, you know, levels of looking at these. I know some look at the long form in depth and make these determinations. And if you determine the driver is not or should not be medically qualified, even if the doctor has qualified them, you know, your determination can trump the doctor's determination, and please do not accept that. The next issue involves signatures. The signature may not be the same name as the registered name of that doctor in your database, or it may only include the last name, or, you know, it may be a doctor's signature and you may not know what the hell it says at all. Those certificates are valid. There are no regulations, guidance, policy, or anything else that talks about it must be the full name of the doctor or the doctor's signature must be legible, et cetera, et cetera, et cetera. So that's a situation where we just have to adjust to the real world as it exists out there and go ahead and accept that medical examiner certificate, even if the name doesn't match up exactly with the name you have on file. Now, one of the things that gets discussed a lot is fraudulent documents. You know, and who's responsible for detecting fraud? I mean, I know that fraud is one of the major concerns of the states at collecting this information in the first place. I completely and totally respect that concern. And the reality of it is you are not responsible for detecting fraud in this document specifically, any more than you are responsible for detecting fraud in any of the documents that are given to you in the process. However, if you do detect fraud through your processes, you know, there are sanctions under our regulations with respect to that. It's a 60-day disqualification, and so to the extent that you do detect fraud, we would ask that you take that 60-day disqualification, take the appropriate action. So we're not going to come in and necessarily, that's all you do. We're not going to come in and necessarily find you in noncompliance if you don't have some robust fraud detection program for these medical examiner certificate. But on the other hand, where you do detect the fraud, we would like you to take that step. Okay, another situation arises where, this involves the exemption notifications, and this was a problem in the past where we were giving monthly updates on the medical exemptions that we're issuing, and now that we have you recording the information and taking downgrade license action, that wasn't working, and it wasn't going to work. And so earlier this spring, specifically in March, we sent an email to all the state driver license agencies' point of contacts with details about our new processes. We're going to send emails, real-time electronic emails. They're going to be password protected, and there's a method for determining what the appropriate password is. And so hopefully that system is up and running and working in all the states. And to the extent that it's not, then I would ask that you let us know so we can touch bases and make sure that we get whatever kinks we have ironed out in that process. Another issue, again, there is a requirement or an requirement in our regulation under 39164 that only entitles drivers a 1-year certification if they're under an exemption. And we have seen some medical certificates that are marked as qualified by operation under 49 CFR 39164. If that certification is for more than a year, which it's not supposed to be, then it's invalid. And then the other thing is if the driver is not under an exemption and the doctor has improperly classified them that way. Again, going back to some of the guidance we gave earlier on the thing, that we consider that to be invalid. If the doctor is not certifying them to the correct type of operation, in this case an exemption when they shouldn't be, then it's not a valid medical examiner certificate. The medical examiner certificate has an expiration date that is 2 years plus 1 day from the issuance date. This is kind of a weird situation. That it's a 2-year certificate and they want to give somebody an extra day for some reason. That's an invalid certificate. According to the way we wrote the specs, it would be kicked back anyway if you put in the proper date, and so the only other option you have is to put in a date that's not the date that's actually written on the medical examiner certificate, and that's not a good option either. And so we have to make that medical examiner certificate invalid and have the driver go back to the doctor and get one that's properly dated. The other thing is if the medical examiner checks the box for accompanied by a waiver or exemption, but the person doesn't have that document, again, then the doctor has improperly issued the medical certificate, and we don't want to accept it. We need to make sure that the doctors are doing their jobs correctly. And so that concludes the issues that we had heard about, or at least I think most of the issues we had heard about in the, from our contacts with respect to the questions that have come up. I actually, as we go to questions, and I know we have a number of questions that have come in on email, we had a couple of questions that, maybe if you could share with us. We have this downgrading requirement to a non-commercial license if the medical is expired, and it raises some questions which we haven't covered in our guidance at this point in time, and we may need to come out with guidance about how we're handling that downgrade, what procedure you're using to obtain the CDL the driver has in their possession when downgraded to a non-commercial license, to make sure that again, they have one document that's an appropriate document. They not carrying around a CDL for long periods of time after they've been downgraded. So what are your procedures for that? And so, to the extent that we, somebody chimes on and does a verbal call or question, then we're interested in hearing some of that information, or maybe we can get it through the EMVA channels afterwards. But again, it's a situation I think we're going to have to develop some guidance for in the near future, and having a feel for what you're doing now would help us. So with that, Kevin or Deanne, do you want to hit us with some questions?
Well, Bill, this is Kevin. We've already sent over probably a half a dozen to you and Bob, and you should have them in your inbox right now.
Okay. First question is, providing certification to users, is email, electronic means appropriate, or snail mail? We are fine with however you want to provide that information, the certification back to the users. Email, electronic means is appropriate. Again, you can collect the information electronically. You can communicate. We don't, get into how you're going to communicate with your drivers. How do we report doctors who are filling out the cards wrong? Okay, here's the guidance that I would give you on that. And what we'll do is I'll get you an email address for this. But what I would think what we would ask is, the first time the doctor fills out a card wrong, that maybe you send the driver back, and hopefully they learn from the mistake. But to the extent that you have a chronic person who just can't get it right, if you email our medical team here at FMCSA, and we will provide an email box for that after, as soon as I figure out from the medical team what the appropriate email is, then we will have our medical folks touch base with the doctor and try to do some education on our end. If the medical examiner certificate is submitted with an expiration date 2 days from the day they come into the office, is that valid? So the question is, 2 days from the date they come into the office. So it's only good for 2 days?
Yeah. This has come up before.
Okay, Bob?
Yeah. I mean, it's up to the state. Some states are saying that, well, if it's less than 6 months left on it, they want them to get a new one. And we basically said that's a state call whether they want to accept it or not, and let them go ahead and get a new one. Because I understand the reasoning behind it is, if you know it's going to expire in a short period of time, why accept it and then have to send a notification out to them?
Okay. Well, again, that's up to you to determine what an appropriate length of time. Obviously, 2 days is completely unreasonable. 6 months, might be a little bit harsh on the driver. I think, somewhere, but anything, 30 days, 60 days, I don't think we're going to argue with you on that one. Next question, are the SID list 5.3 spec changes specific to medical certificate clarifications, or is it more extensive?
Oh, 5.3 is more going to be the learner's permit and testing rule. Yes, if there are some clarifications or things we found that we have to make some small edits, but the majority of 5.3 is still going to start concentrating, I think, more on the learner's permit and testing rule. We will make some change, such as we did it the first time. We didn't realize that there could be more than one variance issued to a single person. And right now, we only have a single field. So we'll add extra fields, things like that.
Okay. The next one, pick the nurse category. Didn't like my story, okay. How valid can the data be if states are randomly choosing whatever category a doctor to pick is closest to? Again, I mean, here, I think that we've got a situation where it's not going to come up very often. I mean, if you look at the 5 categories that we had specifically issued, they cover most of the medical practitioners that are doing physicals today. But again, we had to, I guess, because of some comment to our rule, allow that the states may allow another type of practitioner to do these types of medical exams. And again, nurse was just an example of, if it's a different type of nurse, we have a type of nurse that is allowed to pick the one that's closest. I mean, maybe I'm delusional or wrong. I don't see this being a big enough issue that it's going to seriously distort our data. for the period of time that it's going to take us before we can get that other checkbox into the system.
Right, and again, that's another one of the 5.3 specs. We will, create another for other. We did manage to get, I believe, other onto the medical card that was published in the Registry 1. So it will be coming in to you possibly with the other checked. One possibility is just check the closest one and go back later, keep a list of the ones that are other. I mean, the first 5 are the ones that are mostly going to be giving the exams.
Okay. Is 2 years 365 days times 2?
I would say 2 years is going to be the 2 years from that date. It's going to be the date before. The date expiring would be the date just before 2 years from that date. I don't know, 65. You're going to have some years. You're going to get in with leap year and everything else, so it's going to be hard. But I mean, if it's June 1st it was issued, then the end of May would be 2 years later would be the last day for it.
Okay. So, I mean, if there's a leap year, you get an extra day.
Yeah.
So yeah, I mean, use the calendar years. It's not necessarily 365 days, but, the next calendar year. Okay, and the next question is, what about leap year? Some MECs show an expiration date of 2/29, which doesn't exist in 2014. Or provides an expiration of 3/1/2014, a day longer than would otherwise be provided.
I would say it would be the next day. It would then be March 1st. I mean, it doesn't exist, so it's the next day.
Okay.
Oh, okay. Go ahead. If the date doesn't exist, if the date doesn't exist, how can it really expire? The lawyer and some people would say February 29th doesn't exist the following year or 2 years out, so the medical certificate isn't expired yet. It doesn't expire until that February 29th date. So I think using Bob's guidelines is perfectly acceptable. If the 29th...
The only thing I don't know is I don't know how SIDLIS works, that if the date doesn't exist, will it accept that date? When you put it into the system, that I don't know.
Okay.
The date has to exist because a CDL can be issued on February 29th. Only for given years. Mm-hmm.
Yeah, but does it account for leap years and only allow it in leap years? That's what I don't know. I don't know.
We'll check on that, Bob.
Yeah.
Okay. So this will be one where we're going to have to do some follow-up on the leap year question, which fortunately only happens every 4 years. And have we recently had one?
We just had it.
Yeah.
Okay, good.
Yeah. We're good for 4 more years.
Okay. For the variance notification, would it be possible for FMCSA to also provide a copy of the medical certificate along with the notification of the variance? This will allow us to update the record and not wait for the driver to provide the medical certificate if they haven't done so already. I will talk that over with our medical folks and see whether that is possible. I think it's probably, if we should have it, so I will talk that over with our medical folks and see whether that might be possible.
I know that in the future, as we develop the electronic transmission, our intent is to not only send the medical certificate information, but also the variance information electronically.
Okay. Will the SDLA be required to validate the medical examiner's name on the medical registry prior to the Phase 3 implementation? I don't
think there is any requirement for that because the verification is going to be by us coming through the registry. In fact, you won't have registry numbers right away anyway for examiners until the 2 years from January 30th. So there isn't any means right now for two-way communication or anything. It's strictly right now the registry comes from the medical examiner to to the registry. Now there is requirement for the employer to check the registry number, but there's no requirement for the state to check it.
Okay, so the answer is no. You're not required to. You know, obviously, certainly, if your state wants to implement additional fail safes until we get phase 3 done and check, I think it's probably a very good practice, but it's not a requirement. Next, if the medical certificate indicates corrective lenses and the base license has no restrictions, should the state require that the base license match? And if so, require a vision exam or a vision specialist report?
I'll be done with again. Well, I think that the thing you're going to have is the difference. Yeah, I can see where that can happen because the medical exam, vision exam may be a more stringent one than it is just for the DMV license. So you could possibly pass the DMV test and not pass the medical vision. I don't know. I know I've had the opposite has happened where somebody has said they come in with a medical and says there's no vision problem and they can't pass the DMV test.
Right, and we covered that in our question,
right.
Which is feel free not to give them the license. I think if the medical certificate says corrective lenses are required, that, you know, I mean, again, part of what we're getting into here is, are you required to or should you? Which may be two different questions, and I'm not going to right now answer the are you required to question. I would think that if I was a state or one of the administrators of a state driver's license, I certainly would want to. If I had a piece of information from my doctor that said corrective lenses were done, at least have the guy re-examined, and then, you know, you can, you know, have a basis for not, you know, putting the corrective lenses on there. But if I were you all, I would absolutely want to do that, and we will include that question among, you know, a couple others that we've already noted that we're going to need to get back to this community on. So. FMCSA recently sent us waivers with effective dates in the future. How is that possible? Our system will now allow this to be entered.
What do you mean by
medical waivers with effective dates that are in the future?
That's something I think the medical people are going to have to answer that one.
We'll get back to you. Can we please verify that the medical certificate cannot be issued prior to the medical variance? So states are required to look at both issuance dates prior to accepting.
Let's see. Well, the way it's going to work is you're going to get the medical first. You're going to have two sets of dates. There's no doubt about it. Once you get the medical, and the medical card says, oh, it's only valid with a variance, you're then going to apply for the variance. There could be as much as 4 months difference between them. But you're right. The medical is not valid to be accepted. You can accept it and put it in your system, but you can't validate them as being certified until you get the variance to go with it. In fact, what we are intending, again, we do the electronic. When the person gets the initial medical, the medical probably will not be sent until the variance is ready to be sent, so everything goes as one. So we're looking at these things. Right now we're in the manual mode, but if they submit the medical and they don't submit the variance with it, it's not valid to drive, to put you as certified until the variance comes in.
Okay. And so with that, I think we have come to the end of the questions that have been submitted and transmitted over to us.
Hey, Bill, we actually are sending one more over to you.
Okay.
And you should have it.
I have a comment that Texas agrees that the MedCert information should be included on the variance in protected electronic submissions.
There's another one coming from Illinois. In fact, I'll read it to you. It says, if the intra-city zone box is checked, is the medical certificate valid for 1 year or 2?
1 year.
12 months.
Look them up.
Have not received any additional questions. So with a little bit of hesitation, I'm going to ask the attendees if anyone else has a question they'd like to pose.
Absolutely.
Oh, and one just came in. Let me go ahead and read it. Is the system going to catch doctor shopping? If a driver submits a medical certificate that has been rejected by DMV because the driver isn't medically qualified and the driver doctor shops and is found again qualified, is DMV set up to pick up the driver being previously rejected?
The medical registry is going to be picking that up. The results of all examinations, passed or failed, have to be sent in by the medical examiner to the registry. We're naturally, once we go electronic, only going to pass on the ones that are passed. But there is, there is checks and balances within the registry to check to see if a driver is getting several exams in a short period of time and fails them and then all of a sudden passes. It'll also be looking at doctors that always fail or doctors who always pass everybody. So there's a whole bunch of those built in.
There's no other questions. So again, with hesitation, he asks, does anybody else have a question? Okay, another one just came in. When will NLITs be capable of displaying medical certificate information?
I have no idea.
Okay, we don't know the answer to that question right now, and we'll again I try to include that in the follow-up information we provide.
The only thing I could say is as states come on board with the NLITs, here's
Okay, maybe we do know the answer.
NLITs in itself won't display the information. What will happen is the SIDLIS record will be available through NLIT. So anything that's posted on SIDLIS will be accessible from the SIDLIS records through the NLIT's query. NLIT doesn't hold the data.
Okay, we have a comment come in, and it says, please review the downgrade process again.
okay. The downgrade process basically is once a driver is not certified, whether it's because they never turned in a medical or a medical card or a variance expires, within 10 days you have to go from certified to not certified. Once that is done, that the driver is to be notified that they're about to be downgraded. The downgrading must happen within 60 days. Now, if the driver comes in and says, okay, change my status, my operating status, other than requiring a medical card, fine. They have to make that decision. The state cannot do that. Only the driver makes the self-certification. Now, it doesn't mean wait 60 days. It means within 60 days you downgrade. The driver is responsible for keeping that medical and variances up to date. If they let it lapse, that's their problem. That's the way it is right now, whether it's coming through to you or whether the driver's carrying it on their person. So it basically, some states have told me already that they can almost downgrade instantaneously right after after they change it to not certified. That's fine. Some states have told us they need up to 60 days because of whatever process they have. But as soon as possible, the driver is to be downgraded. I'm hearing states saying, well, we're going to give them 30 days grace period and all. There isn't any grace period because they know when those variances and medical cards are going to run out. We want to downgrade them as soon as possible. Once they go to not certified, they're not eligible anymore. All we're doing is changing the actual license document on them to something other than CDL. But when that goes from certified to not certified, They can't be driving in interstate.
And I believe that's it. We have no more questions that have come in. Well, every time I say that, we get another. Nope. Do we have another one here?
Yeah.
Here we go. With regard to the example where a driver gets a med cert and 4 months later gets a variance, it is my understanding that the med cert would only be valid for 15 days after issuance. And given the 4-month lapse, the SDLA would not be able to accept the medical card with that lapse in date.
No, what I was saying before is take the medical card and put it onto the system, but don't, you've accepted it within the 15 days, it's there. You're right, he's not going to be able to drive, but it's still valid if you post it onto the system. The fact is you just don't put certified in there until you get the variance.
Okay. Is there anything else coming in?
Will AMVA be releasing a new revised CDL manual with the MedCert requirements included in it?
And the answer is yes. We will be issuing a new CDL manual. We normally try to schedule a release in every July-August timeframe with corrections or with changes that have occurred since the previous year. We didn't do one last July simply because we were waiting for the CDL permit testing roll to be released, and it was, but we didn't have time to do the update. Now, we are planning an update for this July and August timeframe. However, we do understand that there are 30-some petitions for reconsideration that may change what we will put in the driver manual. So we are hoping that the answers to all the petitions for reconsideration will come out in such a manner that will give us a couple of months to update the manual. The last thing we want to do is release a manual in July or August and then have to reissue an update because a petition has been granted that changes what the states are required to do.
Okay, I think we're going to have more conversation about that, Kevin. But the news, though, is it looks like the states can expect a manual in July or August. Because even if we grant a petition, all we're doing is saying we will undertake a rulemaking on it. We're not going to change any of the requirements this summer. So granting the petition means that we will do a rulemaking to examine it. But there's going to be a process there, and it will not occur this summer, trust me.
Because there will have to be notice and comments, so there will have to be an NPRM to get comments and then finalize. We'll propose things in NPRM, but we can't go to a direct final on it.
Right. Okay. Okay. Anything else coming in, Dee? Okay, I think that's really going to be it, unless anybody else has a question for FMCSA. And seeing none come in, I think that's going to conclude today's webinar. I'd like to thank Bill and Bob for taking the time to speak with us today, and I hope everybody feels that today's webinar was worthwhile. A recording of the webinar will be available shortly on the AMVA website, and the recording will include all of the questions and all the answers that we have been discussing over the last 25 minutes or so. I'm also going to put a plug in for next month's webinar entitled Drug Driving, a